No.
Okay.
The address is 6155 Stone Valley Drive.
6155 Stone Valley Drive, Stone Valley Terrace.
Yes.
What's the emergency?
89523.
What is the emergency, please?
We have a kidnapping. A son has come in and stolen his mom.
Okay, so is his mother does she have dementia or Alzheimer's?
Yes, he does. But the son there's an order that he has to stay away from her.
How long ago did this happen?
10 minutes ago.
On June 14th, 2019. Dear Steve Moss, it appears as though you're not taking my verbal request to you over the phone. Discharging you as my attorney, seriously. Let me refresh your memory about the events of that call. My son, Roger Hillygus, the successor trustee of the Hillygus Family Trust, and the hand delivered to your office secretary, Cynthia, an original hand-signed letter by Roger, discharging you as the attorney representing me and the Hillygus Family Trust. You told me that paying the final bill would be $2,000. I am confirming the discharge letter written by Roger. I agree with the terms and conditions of the letter.
911, what's the address of your emergency?
I just called in. I'm at Stone Valley Memory Care. It's 6155 Stone Valley Drive.
6155 Stone Valley, and what's going on there?
We had a kidnapping.
You had a kidnapping?
Yeah.
Okay.
I just talked to somebody at Lynx in regards to this. I just had some additional. I have a phone number for the kidnapper, which is her son that's court ordered to stay away.
Hold on 1 second, okay?
Okay, thank you.
I'm just trying to find the call, so give me just a second. What's the information that you wanted to give us?
It's a phone number for the son who's taken her.
What's his phone number?
775-232-5583.
775-232-5583?
Yes.
Okay. And what was his name? Was Roger? Okay.
Hillygus. And for some reason he called in here and said he's not bringing her back. He's taking her.
He just did that now?
Yeah, he's on the phone with my executive director.
He's not bringing his mom back?
That's what he said. He says, I'm not bringing my mom back. I'm taking her home with me. But I personally...
You know what his address is?
He lives in Dayton. That's all I know.
Alrighty. I'll let him know, okay? We do have officers in that too.
Thank you. Oh, yeah, they're here now.
Oh, okay. Go ahead and talk to Ron.
I am, however, disappointed that you are continuing to represent me after we mutually agreed to terminate our relationship. I realize that you believe me to be incapacitated, and that you think you are protecting me from my son, Roger Hillygus. Nothing could be further from the truth.
Retrieve a mom somewhere? I'm Sergeant Handte. I was sent out here by Commander.
Oh, okay. Yeah, I was talking to him on the phone, and we got disconnected.
Okay.
And so I said I was real close here, so I just came by.
Yeah, they're busy.
So one of the things that I hung up on, I didn't hang up on him. The call got lost.
What can I do to help?
Well, I kind of had a dialogue with him, but obviously he's turned it over to you now.
Yeah, they're busy, so they assign these things down to me. So
I was explaining to him that I've got a judgment and
do you want to step outside so we can talk, so we're not in front of everybody? That'd be fun.
To keep him away from my mom. So during this whole process, he called in.
Yeah, he's like, I got all the paperwork, we're giving it to the sheriff. and the police, and there's a federal investigation on all these, and he's just rambling it out. I'm like, if you got the paperwork, I need you to do this. Looks, hey, because this is kidnapping, buddy. You took her, you need to bring her back. You don't have her medications, you don't have anything, you're in danger. He's like, no, I know how to take care of her. And you mail him the meds. Well, no, can't do that. You need to turn around. You need to turn around. No. Like, where are you going? He's like, taking her home. Mail the meds to her home.
And the daughter said that he lives in Dayton, but I don't know what her old address was, if we even have that.
I don't even know.
Pull our file and look. See what we got.
We're not involved. We don't get involved in civil judgments, period. Either side. I don't even care what the judge ruled. The judge ruled that you have full power to walk in there and take the whole facility. That has nothing to do with us. That's a civil judgment. The government has no interest in that, so why would we get involved? So, what I'm saying to you is if you get up there, I would bring all your documents. I wouldn't just walk in there and grab her. I'd go see the management of the facility, show them your documents, explain to them.
He is the successor trustee, and the one I have always wanted to be placed in that position, so please consider. This your official notice discharging you as my attorney. You are to cease and desist from any further actions, hearings, or petitions with the court on my behalf, or by representing any family member. Respectfully yours, Herbert Eugene Hillygus. The contents of that letter bore the weight of responsibility, as Roger was tasked with carrying forward the legacy entrusted to him. The road ahead was uncertain, fraught with challenges and questions, a path that he was now called to walk. The legal battle in the story centered around the guardianship of Roger's mother. Roger Hillygus believed the guardianship was wrongly taken and fought to regain control. His actions included obtaining a jury verdict document to challenge the system in their pursuit of justice. Roger Hillygus and Stewart Handte engaged in a legal battle. Their actions represented a desperate attempt to navigate a flawed guardianship process, challenging norms and risking their own positions for the sake of Roger's mother. The legal battle encapsulated the tension between personal convictions and established legal procedures, prompting a reflection on the complexities of advocating for vulnerable loved ones within a system that might not always align with their best interests.
So, with Susan's meds, is there anything on this list that, if not taken as prescribed, is life-threatening?
She has Ativan, and Risperidone, and this one for the anxiety.
Well, nobody's ever died from anxiety that I know of, but
No,
as
I
far
don't
as
think
any...
so.
I need you to call down there. 925,000. Try to get back through to his medical system. I need a prescription of lorazepam for that resident.
235?
That was, at first I thought that he would do that because that's what he's done in the past.
Have them fax us a script for her so that we can get her some medication so she calms down.
He is married?
He is.
He's aggressive. Do you know that some sheriffs had to remove him with the octane from his house?
From your mom's house?
And the sheriffs wouldn't do it without court order because he threatened that he had guns. And he does have guns. So they go out to Dayton. They need to be aware what they could possibly be walking into.
And we'll let them...
Okay, but do you understand that my mom's life is in danger right now? In danger.
How?
How?
How? She's with your brother.
Have you heard all the stories that we've been going through? That what
I understand he has... He may have some...
So you
Okay.
believe that she's
There-
not a hazard?
None of your mother's... No, she doesn't. All of her... No, she doesn't. Because I just talked to the med tech, because I got a list of her meds, and I confirmed with the med tech, because all of her meds are primarily for anxiety. mental health. It's not for, there's nothing physical that if your mom does not take medications, she's going to die from. And I confirmed that with the med tech.
RPD Detective Allison Jenkins filed an affidavit in the Reno Justice Court at 4:03 a.m. August 9th, 2019, 12 hours after Roger Hillygus rescued Susan Hillygus from neglect in Stone Valley. Detective Jenkins used false evidence to support her DA complaint. The affidavit was also used to obtain a Judge Ryan Sullivan's signature on the arrest warrant.
Is in custody this morning after an hours-long standoff in Bellflower that ended at 2 a.m.
So he's accused of kidnapping his own mom from a care facility. CBS 2's Cara Finstrom joining us from the complex where it all happened. And Cara, you spoke exclusively with the woman whose apartment they were holed up in.
Yeah, she's the apartment manager here. She knows him personally. She knows his mother. But like everyone else, she is waiting to learn what's next for both of them.
It's upsetting for me being the manager here. There's 55 units and people want to know what happened. What did he do? What's he running from?
Wilma Dester oversees the Bellflower complex where the SWAT standoff took place. She also lives in apartment Q, where sheriff officials say 52-year-old Roger Hillygus, who's suspected of kidnapping his 80-year-old mother from a Reno care facility, was holed up.
At what point did you realize that he was actually, police were looking for him?
When they rammed on my door.
Dester says Hillygus' mother is her boyfriend's only sister, and he showed up about a week ago asking to stay with them.
He takes good care of his mother, though. He feeds her, he diapers her, bathes her. No, absolutely no mistreating that we could see while they were here.
Dester says she and her boyfriend were in the front room when officers rushed in and were escorted out. Hillygus was in the back with his mother, and she doesn't know exactly what happened next. SWAT officers quickly surrounded the complex. Their night vision images show the force that was in place for hours. Dester says she doesn't have a gun in her apartment and did not think Hillygus brought one. Reno police have been looking for him and his mother since last week. They say he and the former sheriff of Mineral County, Nevada, who's been arrested, went into her care facility, provided false information, checked her out, and called saying she would not be brought back.
I think that was the main thing. He wanted to get his mother and take care of her. But then there's a sister up in Reno that resents this. And what is over, I don't know.
Ultimately, authorities say Hillygus fell asleep and they went in, taking him into custody safely. His mother, who needs to have daily medication, is now being checked out. Dester feels frustration all this unfolded in her apartment. But more than anything else, she says she just feels sad.
She's very sweet, so she really don't know, what's happening.
And Hillygus was arrested this morning. The sheriff's department has confirmed on an outstanding warrant, which appears to be from Reno. Jasmine DeMarco, at this point, we don't know what possible charges he could face. And at this point, apparently they are still checking out the mom. She has not been taken back quite yet.
You were aware of what happened, right? Here's a little more. Apparently, he shows up with another goon, and he says, I'm signing Alice out. He goes and gets Mrs. Hillygus, and there's a witness who sees them pulling her, shoving her across the parking lot. He was pinged in Truckee, apparently. Was that this morning or yesterday?
Yesterday.
And this, really, it's a crime. It's a crime of kidnapping. It could be a crime of, that's a Class B felony, probably. Isolation, elder abuse.
Well,
problematic. Anyway, I don't want to get sidetracked on that. We're here to confirm the property. I'm sorry I interrupted you. The title company is balking at a close any sooner than 30 days because they're afraid that Mr. Hillygus is going to appeal. And I think this is what I'm about to say is true, is a matter of law, that upon sale to a bona fide purchaser in good faith, his cause of action, if any, from this sale is against the trustee and not against the real property. Would you be willing to add that to the order? I'm hoping it gives the title company some comfort so we can get this thing closed sooner.
Any objection to that, Mr. Spitzer?
No, Your Honor. I would likely sign. Before we go too far down this, I just want to make sure you don't have any quarrel with this, Mr. Spitzer.
I have no quarrel with that, Your Honor. You do have immediate authority under NRS 159.334 to issue a no contact order under the guardianship statutes.
Mr. Earl?
My only additional thought is under NRS 159.305 that you're dealing with just general exploitation, potential abuse, and so forth, and under those statutes, then likewise the guardian would have authority, or an interested party.
And my thought about a domestic violence protection order is this: is it's registerable. In other words, it'll go into a state and national database, and it may have more legs, for lack of a better term, than simply, I of course order that Mr. Hillygus have no contact with a protected person in this case, and that is pursuant to Chapter 159. But let's see if we can establish whether or not there's testimony to warrant a domestic violence protection order. So, ma'am, would you kindly stand, raise your right hand, and take the oath of a witness?
Do you solemnly swear the testimony you're about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God? I do.
Please go ahead and be seated. You can go ahead, if you would be so kind, Mr. Tornabene, and guide some questioning of your client right there.
Ms. Renwick, are you the guardian, one of the guardians for your mother in this case?
I am.
Her name is Susan Hillygus?
Yes.
And what did you discover yesterday? What happened at Stone Valley?
They let my brother in under a false name into the facility because there's a whole new administration, new caregivers, and he hasn't been there in over a year. So they didn't recognize him and they weren't familiar with the situation. Then they allowed him out thinking that he was the son, and he was allowed to take her out even though in her file he is not.
So had you and Ms. Bowers, to your knowledge, previously informed Stone Valley that he was not to take her off the premises?
Yes, his name is not on the list of people that are allowed to remove her from the facility. There's a picture in the back room of him, but it didn't look like him.
And to your knowledge, when was the last time he tried to see her, to your knowledge?
Last July. So he hasn't been there in over a year, to my knowledge.
Are you concerned about your mother's health and safety?
Yes.
Okay, why?
He's not familiar with how much she's declined in the last year. She's completely incontinent. She cannot speak. She uses words and she babbles. She cannot answer a question. She cannot she can't tell you how she feels. She can't tell you if she's in pain, if she's hungry. And she only feeds herself at this point half the time. So frequently the caregivers are feeding her. If I'm visiting, I'm feeding her.
So is what you're saying to the court, without the support of the environment of the institution of Stone Valley, her health and safety could be at risk or are at risk?
Yes.
Okay. Did you hear what the judge indicated to issue a order for protection against domestic violence, OVO you and Ms. Bowers on behalf of your mother?
Yes.
Would you like the court to do that?
Yes.
You believe it's necessary?
Yes.
That's all I have.
The questions you want to ask, Mr. Spitzer?
No, Your Honor, thank you.
Mr. Earl?
Ms. Renwick, could you just describe what you understand to be the situation that arose out in the parking lot that seemed to be important for purposes of the record as to her?
They did not park their vehicle in the parking lot. They parked it across the street.
When you say they, who are you referring to?
I'm assuming it was my brother.
Mr. Hillygus, and whom I refer to as another goon.
Go ahead.
A partner. And so when they started taking her, and her mobility has decreased in the last few months a lot, but she won't stay in a wheelchair because she'll keep getting up. So they were having to literally force, push, and kind of drag her along across the street. That was a long distance for her to walk. And they saw that.
And to whom did you, or from whom did you receive this information?
Tom Taylor, who is an employee at Stone Valley.
Mr. Earl?
And do you have any other details with respect to the car or the nature of the person who was with your brother?
A tall, thin gentleman was with him, is all that I know. And I've just been told by Tom Taylor and another lady that was a former employee there, Lisa Campbell, who saw this happen as well, that it was an older vehicle, looked like an old Jeep Cherokee or a Isuzu Rodeo, which is not a car that I'm familiar with, that my brother owns.
And about what time did this happen?
2:30 yesterday afternoon.
And you were informed right away by Stone Valley?
Once they realized that he was not on the list to take her, they did call me at that point, and I told them he's not allowed to take her to call the police.
Right. And have you heard anything else from the police?
Yeah, the police gave me some updates last night. They pinged his phone in Truckee, California. They called the Truckee police trying to find him. They sent a police officer out to his property in Dayton, spoke to his wife, and she confirmed that yes, she was aware he was going to be taking my mom, that they were the true guardians, and gave them the We the People documents stating that my brother was the true trustee, and also that he took her to California because he believed that the police would not be able to cross state lines to get her.
Person. Let's move now next to the accounting. Mr. Spitzer, I noted, and Ms. Nelson, of course, noted that the accounting includes check registers without payee information, and is, please, I don't mean this too critically, it's just difficult to follow. Any issues you have or concerns you have?
Your Honor, that was the major concern that way, and I think it's simply a matter of some more information in regards to the details of some of those expenditures. Other than that, I'm satisfied in regards to the account.
Mr. Earl?
No objections, Your Honor.
All right, so the statute requires an account be made and filed, which you folks have done, by the guardian of the estate, other language, who is authorized to manage the property of a protected person, but it must include, without limitation, the following information. All cash receipts and disbursements during the period covered by the account, including, without limitation, disbursements for the support, etc. All expenditures must be itemized. So we just need to know where it's coming from and where it's going to, if that makes any sense. I don't hear a great concern about the accounting at this time, and so I'll ask that you make those changes going forward. I don't want to add an additional expense to the out-of-control expenses in Ms. Hillygus' life already. I'll simply acknowledge that the accounting is somewhat incomplete, but I have no concerns in light of Mr. Spitzer's comments. So with that clarification going forward, I'll approve the accounting. Finally, there's a request, of course, for fiduciary services fees and for Mr. Torvinen's fees. Mr. Spitzer?
I didn't request fees.
I apologize for fiduciary services fees then. I'm sorry.
Your Honor, this has been a long, tortured road. I understand that. The amounts are high, but in light of the nature of the work required, I don't have an objection.
Yeah, I note that fiduciary services fees includes invoices for almost $2,000 of fees just to deal with Mr. Roger Hillygus, for example.
And I would suggest, Your Honor, that ultimately the guardian of the estate might attempt to recapture those.
I agree. Let me take an aside in this way. I'm deeply concerned about Ms. Hillygus and her welfare. I dare say I couldn't overstate your concern. It's apparent that Mr. Hillygus has some active mental health issues going on. The filings I'm receiving now are so far removed from reality as to be almost unintelligible, but cause me concern as to his stability. What I mean by that is I intend, if the law would allow me, to retax that 1947 to Mr. Hillygus, but I don't want to push him or anyone else even farther into delusion or psychosis or whatever else may be going on, and so I just intend to be thoughtful about it. Is my only comment.
Your Honor, in my involvement in this case and long observation of Mr. Roger Hillygus, I'm not prepared to reach the same conclusion you are regarding his mental state. He is quite a calculating man. He has adopted the constitutionalist type of attitude that those who've practiced in criminal law have seen over the years in people that are perfectly capable in every other way. In regards to those, Your Honor, I think a cause of action to recoup them by the guardian at some later date might be the most appropriate way to do it. Again, anything we do here is going to be subject to some kind of appeal.
Of course. Well, I would welcome the opportunity to decide with the appropriate jurisdiction at the appropriate time whether or not to retax those costs to Mr. Hillygus. Anything you want to add?
I'll just revisit the initial request to sell the property, and on my end, the position has been that the costs and expenses associated with this have been to the detriment of Ms. Hillygus, and to that end, then I would support the order to sell the home as soon as possible.
All right, thank you for that. So I'll approve the fiduciary services costs, noting that any time chargeable to interactions with Mr. Roger Hillygus should likely be re-examined in the future for purposes of taxing or retaxing them to Mr. Hillygus.
I might add there are multiple orders where fees were awarded against him, and I've never done a request for fees, but I will, and this will all be sorted out there. That was my plan.
All right.
May I be heard? I know you got a lot to do.
No, go ahead.
With regard to the TPO, my client is concerned, and she actually made an appearance and was a party in this case, is Debbie Hillygus, whether you would be willing to add the OBO protection for Susan against Debbie. That's Mr. Hillygus' wife. She was a party in this case.
Well, inasmuch as the evidence I've heard involves no direct action by Miss Debbie Hillygus, at least at this juncture, I would not consider issuing one. I also don't know that Debbie Hillygus falls within the definition of persons against whom a protection order in favor of Susan Hillygus can issue. I just don't know off the top of my head. If you have the statute, we can work through it.
Look it up.
If I can just try and ask one more question of Ms. Renwick. She, in her testimony, she commented that the police contacted her, that she indicated that she was a guardian or they were guardians. Is that what?
Well, no, as I understand it, and please correct me if I'm wrong, Ms. Renwick, the rabbit hole that Mr. Hillygus has fallen down is he believes there is this parallel or other universe through We the People in which he has undertaken a jury trial adjudication of his belief that the court acted without authority, without jurisdiction, etc. At most, as to the real property, I issue an order indicating my inclination to confirm the sale, but until the remitter arrives here at the second JD, I don't believe I have jurisdiction. Authority, without jurisdiction, etc., so that all of the orders in this case are void. And he believes that jury verdict through this We the People process has enabled him to be the true successor trustee and or guardian of his mom. Is that accurate?
Yes.
All right. Service to the process in this case, if I were to step in out of order any more than I already have, let me be more clear. It's fairly unusual for a district judge sitting with family division jurisdiction, as I do in this guardianship area, to sua sponte issue a protection order. It's been done before. I've done it before. I've never seen a successful challenge to it, and so I believe it's within the jurisdiction of me as a district judge. There is a process, however, in the criminal side. You know, I am now a criminal judge, and I believe the law enforcement authorities are going to have to approach the district attorney's office to seek either a warrant for the arrest of Mr. Hillygus, or they will detain and arrest him on allegations of probable cause. It would not be appropriate, I think, for me to opine at this juncture as to whether or not there is adequate probable cause. I just think that would be stepping outside the bounds of my role at this time. So I appreciate the attempt, but I decline to respond.
Just for a remark for the good of the order, when this first happened yesterday, my clients, both of them, ran into the following milieu. Oh, it's just between a brother and a sister. This is a civil matter, when really it's not. And that's what I'm trying to overcome here. I just want you to understand that, where that's coming from.
Well, I can tell you that, in my view, there are a variety of paths that could be taken to recover the person of Ms. Hillygus. More specifically, what I mean is I believe there could be an analogous action for a retake warrant, in the way that if a parent secretes a child in a contested custody proceeding, there is a process to allow me to issue a warrant to include the arrest and detention of the parent or the bad acting parent who has secreted the
It would
child.
be a UCCJEA.
Correct.
Okay, and there's an equivalent in
the UCCJEA applies in Chapter 159 cases by definition.
Right.
And so there may be a mechanism for a retake warrant, as it were, related to the person of Ms. Susan Hillygus. Apart from that, law enforcement is very aware of this case, I can tell you. It would appear to me there is an active investigation. It would appear to me there is some reason to believe that Mr. Hillygus has kidnapped, falsely imprisoned, and or unlawfully detains the person.
In as much as I am a constitutional formalist and very reluctant to in any way be seen as creating law, I give you and Mr. Hillygus notice of the following. In the guardianship case, meaning in GR 14-00159, I take jurisdiction today over the assets in the trust case. That has never explicitly happened before in this case that I'm aware of. The cases have paralleled. They are, of course, in front of the same judge. But I specifically and explicitly today take jurisdiction in the guardianship case over all of the assets owned by the decedent, Susan Hillygus.
I run the show here, not you. That applies for today and forever. Stop talking. Reason. I'm trying to protect you from yourself right now. I haven't made a decision whether your request that your attorney be discharged is granted. Just because you want it so doesn't make it so. I make it so, not you. Your attorney is not relieved until I grant a court order.
Pending before the court today is the big enchilada, the petition for surcharge, but there's also the two accountings for the guardianship, the accounting for the trust, my attorney's fees itself, the release of the additional $22,500 that was agreed to be paid to Mr. Hillygus' wife. That's Debbie Hillygus. I think I got everything there.
Well, so first, I apologize for interrupting, Mr. Torbini, but as to any outstanding accountings, the outstanding accountings were lodged long ago. There has been no objection or traverse filed related to those accountings, and I'll simply sua sponte approve the outstanding guardianship accountings and the trust accountings, making easy, if you will, the math related to those accountings and the argument around retaxing of costs, etc.
Her son and a former law enforcement officials were in Reno Justice Court facing charges for her abduction. Ed Pierce was there.
The story that unfolded in this preliminary hearing in Reno Justice Court had its roots in a bitter battle over the guardianship of 80-year-old Susan Hillygus. Her son Roger had lost the legal battle to his sister in 2016, and by August of 2019, she had made plans to sell her mother's home to support her care. By then, she was living in a Reno memory care facility, ambulatory but mostly uncommunicative. He had apparently not given up and even approached Reno Deputy Police Chief Oliver Miller with a strange request.
He wanted to have myself, Chief Soto, Sheriff Darren Balaam go down there to effect some type of civil arrest against the individuals that were holding his mother in the care facility.
Miller told the court he advised Hillygus the department had no role in what was strictly a civilian matter, and he should hire an attorney and stay away from the care facility, where he had already been accused of trespass. Hillygus apparently found a more sympathetic ear in another law enforcement veteran, former Mineral County Sheriff and Reno Sparks Indian Colony Police Chief Stewart Handte, who Miller said made a similar call to the police department. According to investigators, August 8th, Hillygus went to the care home, told his staff he was there to visit another patient, and took his mother. He later called to say he wouldn't be returning her, but was taking her to California, where authorities would have no power over them. But days later, acting on a secret witness tip, police located them in an apartment in Bellflower, California. He was arrested on second-degree kidnapping charges. Handte admitted his role, but explained he was sympathetic to Hillygus' plight because of his own family's history. His charge was later reduced to conspiracy, but appeared with his friend at the hearing and may share the defense table with Hillygus if this case moves on to trial in district court. Sadly, Susan Hillygus died in October of 2019, a couple of months after her return. In Reno Justice Court, Ed Pierce, KOLO 8 News Now.
Battle.
Alex here with an events video on the state of Nevada versus Roger Hillygus, a case involving a man who allegedly, with the aid of retired Sheriff and Police Chief Stewart Handte, went into an assisted living and memory care facility and removed his 80-year-old mother, Sue Hillygus. Reno police tracked Mr. Hillygus to a home in Bellflower, California, and took him into custody after a brief standoff. Interest in this case stems from a flurry of media coverage that followed after a number of guardianship watchdog groups closed ranks around Mr. Hillygus, bolstering claims that his mother, who has since passed, was held in a locked facility against the family's wishes. Prosecutors leveled charges against Mr. Hillygus in Handte, bringing 5 felony counts for kidnapping and unlawfully removing Ms. Hillygus with the use of forged legal documents. We filed a media request and the Washoe County District Attorney's Office objected. Justice of the Peace Ryan Sullivan decided to hear the objection on the day of a preliminary hearing, at which point Deputy District Attorney Amos Stegg asked that his face not be on camera because he feared for his safety and requested that Channel 4 News should take over coordination of the camera pool on the basis that he didn't know who we were. Ms. Sullivan rejected his request, barring Channel 4 News cameras in their entirety and pronouncing from the bench that our media request was granted, but proceeding immediately without giving our camera team an opportunity to set up and actually record the proceedings. We filed a request for the JABS recording, which is now pending, and in the meantime, we'll continue monitoring the case in the hopes that we'll be able to provide coverage of the continued proceedings on March 31st at 1:30 p.m. Mr. Hillygus is representing himself. Mr. Handte is represented by Joey Gilbert. The state of Nevada is represented by Amos Stegg, Tyson League, and Wesley Duncan. You can keep up to date on our coverage schedule by visiting www.ournevadajudges.com, and as with our previous videos, feel free to post any questions you have down in the comments below, or you can send us an email at admin@ournevadajudges.com.
Are you saying that Mr. Torvinen's fees are solely designed? Well, let me ask you this question. Who does Mr. Torvinen represent in this matter, to your knowledge?
The trustee and the guardians.
And who are those people?
Kelly Lund, Fiduciary Services of Nevada, and myself.
Okay. Now, when he's do you understand the difference of him representing you as the guardian or the trustee and him representing you personally in this action?
I'm not sure.
Well, let me ask you this question. Why is it that all of the work being done, I'm sorry, Judge, let me rephrase that question. Have you reviewed the billing of Mr. Torvinen?
Yes.
Have you gone over it with him?
Yes.
Okay. And do you have no issues with that billing?
No.
Okay. You have not filed an objection or anything like that with the court, have you?
No.
Okay. And relative to the monetary division that is to take place in this case, have you attempted to negotiate a lesser fee with Mr. Torvinen other than the now $81,000 fee we're subject to?
Are waning
yes.
And we'll lose our liberty.
And was the result of those negotiations expressed by Mr. Torvinen on the record?
Yes.
Okay.
Are you
now? Can you indicate for me,
willing to stand with
and I'm not trying to put you onto the spot here, but can you indicate for me in Mr.
Torvina's billing records, the difference between work he is doing for the estate and the difference in work he is doing for you as trustee or guardian.
Separately. Are you together? Are you going to the tree?
Your Honor, I object to that question. Working for the estate. The question was working for the estate and working for you as guardian.
It won't get any easier to regain lost liberty. Strange things are happening in this land.
Well, I guess the objection, Your Honor, is the form of the question.
So, brother, I ask you.
It's nonsensical.
Are you?
I'm not asking for additional
Are
arguments.
you?
All right, I won't.
Going to stand by me.
Thank you, sir. Thank you, Your Honor. So, is it your intention today to have the division that is on page 10 of the petition be the order of the court?
I object to the extent that that question does not reflect the modification I made at the beginning.
Subject, I'll re-ask the question, Judge. I'll save the time. Subject to the modifications made at the beginning of the hearing, is it your desire to have page 10 be the order of this court today?
Yes.
Okay. Can you explain for me how it is that at the end of that accounting, Mr. Hillygus' share becomes yours?
Objection, Your Honor. That calls for my client to give a legal conclusion.
Next question.
Okay. So, are you aware that the remedy that is being sought by Mr. Torvinen is for you to get the entire 152,150, the number changed, whatever the number was at the beginning of the hearing, that entire balance is your sole and separate property. You do understand that's the relief he's requesting?
Yes.
Why do you believe you're entitled to that?
I believe that none of this would have even happened if it weren't for Roger's bad faith starting in 2013. I believe all the attorney fees should be charged to Rogers.
Are you going to agree? Our freedoms are waning and we'll lose our liberty, slipping one by one until there's nothing left to see. Are you willing to stand with me? Are you just going to let it be? The ranchers are first, but brother, next it may be me. We all stand together or we'll hang separately. Are you going to the tree? Are you willing to be free? It won't get any easier to regain lost liberty. Strange things are happening in this land that once was free. So, brother, I ask you, are you going to stand by me?